So this is about how to leave an inheritance to children or grandchildren or others who are in the maybe age range of early 20s or younger. So I've done estate planning for a lot of people who have children, who have grandchildren. Let's mainly talk about the children here. And those children are young. Sometimes they're still minors. Sometimes they're young adults, maybe 19, 20, 21. And those parents want to provide that if the parents pass away, the parents don't want to just dump a bunch of money into a maybe not quite so mature young adult. So here's the analysis that we typically go through to get all that stuff straight. So maybe I'll go through about three things. The first thing is, where do all of these provisions go? And sometimes people put these provisions in their wills in what's called a testamentary trust. Parents have wills, say when we pass away, we leave things to our children in trust under the following terms. Sometimes parents set up a trust and put assets in the trust for them while they're alive, and they just stay in trust after the parents pass away for the children. That's often a probate avoidance mechanism there. Sometimes parents set up a life insurance trust where their life insurance is owned inside of a trust. Sometimes that's done for estate tax avoidance reasons. And then when the parents pass away, those insurance proceeds remain in the trust for the benefit of the children. So there's a bunch of different ways to arrange it. But this is the how do you leave it to them discussion. So the second part is assuming you don't want to just dump it in their lap. And really, if they're a minor, it's a complete nightmare. If a minor inherits, things have to go through the courts. It's a mess. So one decision is who should be the trustee of a trust for those minor or young adult children that you leave behind. Now, that trustee or trustees can be individuals. And again, we're assuming mom and dad have passed away. And so sometimes they designate a family member, a trusted friend, to be that individual trustee for the benefit of their children. Sometimes a corporate trustee is designated to be the trustee after mom and dad pass away, large financial institution, trust company. So number one, you have to select who's going to be the trustee. And then where there's a lot of discussion typically is what are the terms of that trust? When can the children get it? And there's a million different scenarios. Let's go through a few. I'd say we'd start with kind of a default provision that says if our children are younger than 25 when we pass away, then their inheritance will be held in trust by the trustee until they're 25. Or maybe you provide that it goes in stages to them. They get a third at 25, one half of what's left at 30, the rest at 35. Maybe you give the trustee the discretion to determine when your children get it. So if you have a trustee that you really trust, then maybe that's the best solution because you never know how your children are going to turn out. And if it's dumped in their laps at 25 or 30 when they're not ready, could be a problem. So trustee discretion is another option. An area where people get hung up a lot is sometimes parents say, well, I don't want to lock it up for them until they're 25 or 30 because they won't be available to them for their education or for their college. Always got to come back in and say, you know what? Even if you say they don't get the principal until they're 30 or 25 or whatever it was they designated, it's very common for us to have these provisions in the trust for the children to say that if the trustee determines that the beneficiary, the child, needs the assets that are in the trust for and then the common standards are health, education, maintenance, and support, HEMS, that HIM standard, then the trustee has the discretion to use the trust assets for those purposes, even though the beneficiary hasn't reached that age. So let's say parents die, there's $250,000 in a trust for their child who's 16, but the trust says that the child doesn't get it until they're 25. But there are these provisions in the trust that allow the trustee to access principal for health, education, maintenance, and support. So when the child is 17, 18, 19, going to college, the trustee can use those funds to pay for the education of the child, even though the child doesn't get the principal or can't demand the principal until a much later date. So know that you can have a later date for the beneficiary receiving the principal, but it can be used for certain things before then that you provide. So that should give you an idea. One, make sure you leave things in trust, whether through your will or your trust or some life insurance trust, or name a trust as the beneficiary of retirement accounts if you're leaving that to young people, so that these youngsters don't get it, in a lump sum. And if they're minors, it's a real disaster if they're named individually as a beneficiary or an heir. And then 2, designate the right trustee or co-trustees, individuals, corporate trustee. Again, got to pick the right people, got to have backups perhaps. 3, know that you've got some options on when your child can ultimately receive the assets. And even if that's postponed, that you can make provisions that the funds are available for their education, their living expenses, health, education, maintenance, and support, or common standards. So they're not going to be deprived, before that trust termination date. So, and again, that termination date could be set at an age, or it could be in stages where they get it over time. If they mess up with the first distribution, they've got 2 more distributions to act more mature about. So lots of options there. Those are typically the things that are discussed. Make sure you take care of those kids you've been working so hard to take care of. Have a great day.